You're watching News at Prime. Let's bring you this discussion now. There's been mixed reaction to Solidarity's purported agreement on contentious clauses in the Basic Education Laws Amendment Act, or BELA for short. The union says it reached a deal with the Basic Education Department and AfriForum through the National Economic Development and Labour Council. Under the agreement, language and admission policies will no longer be implemented. Let's speak now to Nedlac Executive Director Lisa Seftel, who speaks to us from Johannesburg this evening. Lisa, good evening to you and thank you for your time. For the record, is there an agreement between Solidarity and the Basic Education Department on BELA?
Let me just say that there is an agreement, not with AfriForum. Solidarity is a trade union, and Nedlac is empowered in terms of the Labour Relations Act to get involved in potential socioeconomic disputes with trade unions. Let me also just say that the agreement is not a settlement on what should happen with Schedules 4 and 5, but it is an agreement that the Minister of Basic Education will recommend certain issues to the President for his consideration.
So it's not an agreement, but a settlement. Could you clear that up for us? What's the difference?
Okay, so there is an agreement. There was an agreement signed between the Minister of Basic Education and Solidarity. And because that agreement was signed, within Nedlac, there is something called a Section 77 Standing Committee that hears from parties who've got a dispute and they want to embark on a socioeconomic action, which in other words is a protest action or a march or a stay away, and they want to be protected from dismissal. Then they come to Nedlac and there's an opportunity for engagement. And if the Standing Committee is of the view that either the engagement has happened and been successful, or the engagement has happened and has not been successful, then the Standing Committee can indicate that the matter is settled or considered. So in this instance, after 3 meetings and a lot of deliberation between the DBE, the Presidency and Solidarity, the Standing Committee was of the view that, and that we were given documents to show that there is an agreement between the parties, in which case then the matter is settled. They don't no longer need to go on a socio-economic protest action as they had initially envisaged.
All right.
I hope that clears things up.
I think you have gone some distance, but let me pose another question. Is this agreement binding, therefore? If so, what happens to the parliamentary process?
The agreement is only binding on the parties. The agreement does not bind the parliamentary process or the GNU process or the president or the clearinghouse or the deputy president or anybody else for that matter. It is an agreement between Solidarity and the Minister of Basic Education about the issues that she should raise with the president as a solution to this matter.
You have heard the disquiet then on the back of this agreement. SATU, for example, the biggest union in the education space, saying that for them, this isn't an agreement because if that were the case, then it means that Solidarity, which they view as a lobby group, a right wing, and I've got to put that in inverted commas, these were their words, a right wing group, it means then that this country is effectively moving backwards. Why wasn't there an inclusion of such unions, SATU, NAPTOSA? These are very well-known unions in the education space.
Okay, so as I indicated earlier on, with this process of Section 77 of the LRA, a union is entitled to bring a dispute. And then what is discussed in Nedlac is only about whether the dispute has been engaged upon meaningfully or not. If the dispute has been meaningfully engaged upon and there's a resolution between the parties, then we can say the matter is considered. And a report is written, which will be on our website in a couple of days. If, again, there is engagement and no resolution is arrived at, but the Standing Committee can see that the engagement has been substantial, then we will regard the matter as considered, but we will issue a certificate which will allow for protective socioeconomic action. So this is a very particular process in Nedlac. Any other process in Nedlac around consideration of policy and legislation would have to be inclusive and would include organized labor more broadly. And in fact, in those deliberations, because Solidarity is a union and not a federation, Solidarity is not part of those Nedlac processes. So this is a very specific Nedlac process, which is about the attempt to resolve disputes before a certificate is issued to allow a socio-economic protest.
Let me put this in a much simpler way. Was this process inclusive if you have contestation from other unions? Because it's clear it was Solidarity and DBE. I will pose another question as to the parties involved here, but just clear that up for us, please.
So, as I said, the Section 77 of the Labour Relations Act and the associated code does not require of Nedlac or the Nedlac Standing Committee to bring other unions to bear because it's a specific dispute. It would be like you're discussing wages in a sweet factory and you want to bring the sugar workers to bear. You can't do that. It's just a sugar factory dispute. So I hope I've been able to clarify that.
In essence, Lisa Seftel, could this agreement, in inverted commas, come undone at any point during these deliberations? Because what we know is that there is a date of 13 December. The president has allowed for parties to try and find solutions. In his statement, he made it clear that if there is no agreement among parties, then what he signed much earlier, I think it was in September, that still stands. In fact, I just want to play us a soundbite of the president, but he was speaking here in his capacity as leader of the ANC. It was on the back of a by-election campaign in Tabazimbi. This was on Sunday. Just take a listen to him briefly, please.
In the end, the president has signed the bill, and I've given 3 months for solutions to be found, and those solutions have to be credible. They have to be solutions that everyone buys into, and my resolve in having given people an opportunity to find solutions should never be abused. It should never be diverted. It should never be downplayed. I am quite resolute in saying that come the 31st of December, if there's no solution, what I signed into law is activated.
Lisa Seftel, there are specific words in what the president said. There has to be solutions that everyone buys into. I repeat my question, therefore. Could this so-called agreement come undone?
So yes, I think it could, because my understanding of what the president said is that the parties in this case is not Solidarity, but the parties are the parties to the GNU. And my understanding is, we did try and clarify it throughout the process in Nedlac, is that this is a process which will be an input into a GNU process. But Solidarity reminded us that they're not in the GNU. So that is why they wanted to use power. They wanted to go on a protest action. Yes, there's nothing in this agreement that binds the parties in the GNU. The parties in the GNU need to find a solution, and the president has said they need to find that solution within the month of December. And yeah, I think that's how I would respond to that. Yeah.
Okay. Who from the presidency participated in this process?
The office of the presidency participated in this process.
The office of the presidency participated in this process?
That's right.
You're not at liberty to tell us names?
No, definitely not.
And I'll tell you why I'm asking you this question. Helen Zille, she's from the Democratic Alliance. She says, and I quote, "In particular, it is incumbent upon the presidency to uphold an agreement it was party to. The representatives of the presidency involved in the negotiations regularly reverted to the principles to seal their negotiating mandate." When you juxtapose what I've just read to you and indeed your confirmation that the presidency did indeed participate here, you try and marry that to what the president said in that clip we've just played. Who is fooling who?
Let me just say that this is a very contested space. And we must always be mindful of that. So one of the things that myself as chairperson of the Standing Committee needed to do was to satisfy myself and my fellow members that when the parties signed the agreement, they had a mandate to come to the dispute meetings, and they had a mandate to settle. And that was confirmed. But as I said earlier on, my understanding of what was agreed was that there was no agreement on the resolution of what should happen with Schedule 4 and 5. What was agreed was that the minister responsible for DBE would put issues for the president to consider. And I think that's the heart of the issue.
Yeah.
And I do think that some of the ways in which this has been conveyed by the parties has not clarified that enough.
Yeah. Final question to you, Lisa. When all things are considered here, is it too simplistic to say that Nedlac's interest here was to prevent a mass action or was to prevent a strike by Solidarity, and therefore you wanted to pacify them, but that does not mean that the agreement is binding because it could still come undone?
So as I said, the agreement is not binding on the GNU. Definitely we were not pacifying them. But there is a prerogative, a mandate in the Labour Relations Act. The Labour Relations Act is about achieving industrial peace. Nobody wants socioeconomic protest. But the role of the Standing Committee was not to settle at all costs. And we don't have the tools or the legal authority to settle and bully parties to settle. All we have to do is that we have to encourage them and enable them to seriously consider the matter. We had another Section 77, which we resolved the day before, where we have issued. We are about to issue a certificate that they can go on a socioeconomic protest. So all we were doing was creating the platform that if there was the possibility of a settlement, that there was a settlement. So definitely we were not in it to bully or pacify any trade union.
Lisa Seftel, thank you very much. I suspect you and I are still going to have a conversation at some point in the future. Nedlac, Executive Director there. Yeah.